good morning or good afternoon, depending on where are you located right now. And welcome to this webinar about general data protection regulation with the Spain-US Chamber of Commerce and Telefónica. But before we begin, I would like to thank everyone who joined this session to be part of the Spain-US Chamber of Commerce and participate in this webinar. As you may know, we host many different events during the year. Many of them are online, like this one, and we try to address many different topics that might be useful for your companies and for also people that are interested in business and commercial relations. So in order to be updated in every activity that we host, I encourage you to visit our website, which is SpainUSChamber.com. And there you will be able to check all the events that we are preparing for 2023. And we are really excited since we are organizing many different activities. In fact, last Saturday, we hosted a sports events only for those that are living in Miami. But we organize and we schedule many other different activities online that everyone could enjoy. This webinar, as all the webinars that we host, it's being recorded, and we will share with all the attendees the video so that you could share that with your colleagues and friends that might be interested in this topic. We will also post it in our YouTube channel so that you don't have to miss anything if you need to leave a little bit earlier. And also, we will share with you the presentation so that you can take a look to everything that it's been discussed during this webinar. And of course, the contact information of our guest today, this group of experts that will guide us through all this incredible journey about data protection regulation will be available to you, so that in case that you need to contact them for specific questions and needs, they will be more than happy to help you out. And we will share that contact information not only in this presentation at the end, but also we will send you an email with that email information and telephone numbers of the experts. And last thing, we will have a Q&A at the end of the presentation. So once we finish with the webinar, we will open Q&A so that every attendee could send us all the questions that you have. And for that, you don't need to wait until the end. We can receive all the questions during the presentations, and the only thing you need to do is to send those questions through the control panel that might appear in your screen right now. Probably on your right side of the screen, there's a control panel, and you will find a tab that says questions. You just need to click there in questions and send your questions or your comments right away, and we will receive all of them and address all the questions at the end of the presentations, but you don't need to wait until that time. And without further ado, I want to thank very much Telefónica, and in particular Govertis, which is a company that belongs to Telefónica Tech, which is part of Telefónica Group. And they will be the experts today. Govertis is a leading cybersecurity consulting firm, the largest advisory firm, 100% specialized in governance, risk compliance, and integrated risk management, including IT compliance, cybersecurity, IT, OIT, governance, and many other legal aspects that the technology is bringing to us. And in order to learn about everything related with this side of the industry, we have three experts with us today. First, we have Felix Aro. Felix is lead advisor, international and large enterprises projects at Telefónica Tech. He is a member of the International Association of Privacy Professionals, and he is certified information privacy manager, as well as certified information privacy professional for European and US legislation. So welcome, Felix. We also have with us Maria Loza, currently lead advisor, emerging technologies at part of Telefónica Tech. She is a lawyer specialized in data protection and privacy with more than 15 years of experience, PhD in law, certified data protection officer, certified data privacy solutions engineer by ISACA, lecturer at the University of La Rioja, and vocal of the ICT law section of the Barcelona Bar Association. Welcome, Maria. And also we have with us Fabio Musumeci, Director of Compliance and Global Procurement Services at Apollo Intelligence. With over a decade of experience in the market research sector, he ensures that regulatory requirements are addressed in their respective procedures, and he oversees internal teams to ensure that they operate in a compliant manner. So welcome also Fabio to this webinar. And well, without further ado, I'm looking forward to learn more about this, and especially these days that we have a lot of things in the news related with data protection. So thank you so much, and Felix, I leave the floor to you.
Thank you, Juan Carlos, for the introduction. Let's go with the first slide, please. I'm sure that many of you are asking yourselves a simple question. How is it possible that a European regulation applies to me or my company? Why? I have bad news for you. I have to tell you that yes, although there is a lot of distance between Europe and US, that privacy legislation can be applicable to your companies. How can we know if we have to apply that GDPR, that legislation in my company? First, you have to ask yourself one question. Do you work with personal data? Do you work with data belonging to people? For example, name, email addresses, phone numbers, and so on. If your answer is yes, you have taken the first step. Let's go with the second one. Once you have confirmed that you work with personal data, you have to check if you sell products or services to people residing in any country of the European Union, or if you control the behavior of your customers and they also reside in the European Union. If you say yes to either question, then your company, despite being in the United States, you have to comply with this regulation, with GDPR. What is the reason that led the European Union to do that? We should ask big tech companies, which use tons of personal data worldwide. This data processing have an impact worldwide. And the European Union considers the right to privacy as a fundamental right. This is the reason why it has wanted to subject any company to the world to the European regulation, so that the privacy of people is respected under European parameters. To better understand our obligation, we could say that GDPR is like a specific highway code. It tells you how you have to drive personal data. It is very difficult to summarize all the legal obligations. We don't have time here to talk about all of them, but I will tell you the main ones. For example, GDPR tells you what information you have to provide when collecting personal data so that your customers knows what's going to happen with it. It tells you how long you can keep that information. GDPR tells you what you have to demand from service providers who help you to deal with data. GDPR tells you that you have to train your employees so that they know how to work with personal data and security. GDPR tells you that everything you do with personal data put security measures. There are many, many, many more obligations, but I want you to remember the next message. GDPR is like a specific highway code that tells you how to drive with data. It has rules for everything you do with them. Next. I have chosen for you a real example of something that took place in the United States when the GDPR came into force back in 2018. A lot of online newspapers had to close their editions to European readers because they did not comply with something as simple as informing them about what personal data they were processing using the well-known cookies. The European Union required clear and express consent before installing cookies. Can you imagine just for a moment how much money was lost on advertising? If I have to close my online newspaper to a number of visitors, I'm losing money. If I lose money for not complying with the GDPR. And of course, if you do not comply with the regulation, in addition to losing money, a European Data Protection Authority could sanction you with administrative fines up to 20 million euro, or in the case of an undertaking, up to 4% of the total worldwide annual turnover the preceding financial year, whichever is higher. Can you imagine that? Let's not talk about this. I really hate talking about fines. Next. One of the most unfulfilled obligations by companies outside the European Union, which sell products or services to EU residents, is to appoint a representative there. The representative shall be established in one of the member states where the data subjects are. The FIFA, the International Football Federation, had a security breach years ago. The federation is based in Switzerland, and they had appointed a representative in Hamburg, Germany. That is correct. They had a security breach with personal data of their volunteers, and they had to notify it to the Hamburg Data Protection Authority. All that with the help of this representative. We have now learned two more obligations: to notify certain security breaches with personal data and to appoint a representative in the European Union. At the end of the representation, Fabio will give you another very good example of this obligation. Next, please. What to do then? I have obligation as a company, but GDPR talks about giving clear information to my customers, taking care that my service providers also comply with the rules, putting security measures in place. There are more obligations to fulfill, but they all have something in common. And that is what I would like to end my speech with. I would like you to remember from GDPR the following short and clear message. GDPR means customer trust in my company, in my products, in my services. Now my colleague Maria will tell you more interesting things about GDPR and IoT. Thank you very much.
So thank you, Felix, and good morning, good afternoon, everyone. Thank you very much to the chamber for the invitation. After the brilliant explanation of my colleague Felix, I'll talk about how to apply it to the IoT ecosystem. But first of all, it's necessary to know the characteristics of an IoT solution. E stands for enterprise because we are thinking in a business environment. So on the left, we have the most simple architecture with has 3 layers, the 3-layer scheme. And the first layer refers to the device where through the sensor we collect data. That's why it's also called the perception layer or sensorization layer. Also in this layer, we can generate actions in the environment, such as turn on a light or similar, or send data to other devices nearby. But the collection of data is the main processing activity in this layer. Also, we must say that if all data are locally developed at the device layer without involving any other layers and any other company, the exception of household activities would apply, but only in this case, when no actors different than the user are involved. In the second layer, the communications is also called the gateway or the transport layer because it allows the exchange of data between the previous layer and the next. So between the device layer and the service layer, or the exchange of data between devices. And here we include all the infrastructure that provides means to enable the communications. And in the third layer, is the service or the application layer, where the personal and more complex personal data processing is made with different analytics techniques. And also in this layer is the one that generates more the main business value for the company. And on the right, we have a more complex model, typical in a business model, a multi-layer scheme with 4, 5, or even up to 7 layers. So depending on the complexity of the IoT solution, we could find more layers. And in an IoT solution, we'll have in the top the business layer, and we can find also the pre-processing layer that is interesting because as the volume of data we collect in the first layer, in the sensorization layer, is very high. In this pre-processing layer, it's very positive from privacy and security point of view because much of the data coming from the devices wouldn't cross the network in this way. Later in the processing layer, we store the data, we make big data analysis, reports, and machine learning. Next, please. So once we know how an IoT solution works, we need to know who are the different roles in each part. As we know, the IoT market is complex and is highly fragmented. And in the device layer, we have the manufacturers of the devices, when they develop the operating system or of the device or its software. In the second layer, in the transport layer, where we collect data from sensors, we pre-process data and we send data to the application, to the backend. We find the company and also the device manufacturers that send the information to the cloud. And also the cloud could be a non-cloud or a third-party cloud. And in the third layer, in the processing, we find the same actors as in the previous one, and we add the service providers for these processing operations with big data or machine learning. And finally, in the application layer, we find the same actors as in the previous, plus the owners or developers of the applications. Also, we may find technology service providers and IoT platforms. Very important, the IoT platforms in this layer. And also, we could add other large data recipients and intermediaries like the application stores or marketplaces, or intermediaries like the advertising relations to advertising, or other parties such service providers of analysis or usability or similar things. Next, please. And which role have these actors in relation to data protection? So first, we have to say that in an IoT solution, the main controller would be the company, that is in the business layer at the top of the architecture we've seen before, because it's the main controller, because this company is the one that decides to use a particular IoT solution for a specific purpose. But analyzing an IoT solution, we can say that the role of the controller is not only for the company using the solution. In the device layer, we find device manufacturers as controllers when developing the operating system or the device or its software. And also, the company and the device manufacturers have the role of controllers in the second and in the third layer if they process data in some manner. Also, we find here other processors which carry out the processing on behalf of controllers, such as service providers for these processing operations. If we think, for example, in storage, big data, or machine learning, or any kind of reports. And in the application layer, we find also, as a controller, the IoT platforms and the applications owners that interact with the final users. And as processors, we find the application developers and hosting providers or other service providers. Next, please. And once we know which are the roles involved and its position, from a controller point of view, a company who decides to use an IoT solution, what are the obligations to comply with concretely? So it's obvious that the solution will be already done, but it's very important to understand all these obligations for the company to choose an IoT solution. For example, if the solution is privacy by design, so the controller may inform the data subject properly and other things, and also to know what has to be done in all the rest of the life data cycle. So GDPR, the company needs, first of all, a ground for processing. And this obligation is for the company, not for the IoT solution provider. The one that has to decide the ground for processing, is the company. Second, providers involved, if they are processors, they will have to sign a DPA, but before that, the controller will have to analyze that the provider is reliable, is trustworthy in terms of data protection and security. And also, a privacy impact assessment has to be done, in which has to be analyzed first, the necessity and proportionality of the solution. Second, all these aspects of compliance, like a risk assessment, how to comply with the information duty or consent from the data subject, and so on. And also, we have to bear in mind other legal compliance, such as the future AI regulation, because it's quite probable that AI is involved in an IoT solution. So here we have to include also the companies we have seen have a controller role, because in this case, the main controller has to ensure that data is not used for any other purposes, no? That the purposes and means of the processing and everything is GDPR compliance, no? For the main controller to be sure that there are no other parties involved or data used by third parties for non-authorized purposes. And next, please. And from a data processor perspective, that is part of an IoT solution, will be very interesting to comply with all these requirements as a competitive advantage in relation to other competitors. This privacy, the GDPR, has not to be seen as a burden. It has to be seen as an advantage in relation to the business, no? So the processor will have to ensure and demonstrate to controller that everything is GDPR compliance, that data is not used for own purposes, it has a record processing activities as a processor, a DPA, where it has to be very clear the outsourcing issue, an international transfer, risk analysis done, and any other additional guarantees that the processor may bring, like security certifications or other things like that. So the better it is done, the better for the processor and at the end for the data protection rights, and also at the end for the business. And now my colleague Fabio will continue. Thank you.
Thank you, Maria and Felix. Good morning and good afternoon to everybody. So today I'm going to share with you some steps that we found very useful to determine our approach to the GDPR. In this journey, you want to start mapping the structure of your company, which could be quite complex for a large organization with operating companies offering services in different geographies. In this example, I'm just providing the idea of a parent company based in the US, which operates with a couple of affiliates based in the US, providing services to US citizen or European and British citizen, as well having another affiliate based in UK, offering services to European and British citizens. Next, please. In the second step, I propose to map the interactions across the entities and how the personal data collected by one company might be shared across the other sister company or the parent company. And this could be the result of this, how an organization is set up. You may think that a parent company may be structured to have certain departments that are centralized. Think about HR department that is providing the service to all the affiliates. It means that the UK affiliates will need to send the HR data to the parent company based in the US. Another way that data collected by one company may be shared is a sales department that is centralized at parent company level and is receiving personal data of their customers based in Europe. Or at the structural level, if a company may have servers based in the US or in a different company, and all the affiliates are using the servers. So mapping the interactions and all the path and flows of the data across the company is very important then to determine the third step. Next, please. Now, based on information that you have collected about your company, you can start building your compliance with the GDPR. Remember, Felix mentioned the Article 3, the territorial scope of the GDPR. And in accordance with the paragraph 1, any establishment of the controller or the processor that is based in Europe will have to comply with the GDPR. This means that our affiliate based in UK by default has to comply with the GDPR and needs to put in place certain steps to be compliant. As a matter of an example, I'm putting here just the records of processing activities. Make sure that to register with the ICO, which is the Data Protection Authorities in the UK, to nominate a DPO, and where it's required to conduct a data processing impact assessment. However, the Article 3, Paragraph 2, the so-called extraterritorial reach of the GDPR states that the GDPR applies to the processing of personal data of data subjects who are in the European Union by a controller or processor not established in the European Union. This means that an affiliate that is based in the US, like the affiliate number 2, that is providing a service and it's collecting personal data of European citizen will need to be compliant with the GDPR. Felix mentioned that one of the requirements is to nominate the representative. And remember, if you are providing service in the European Union and UK, you may need to nominate a representative in both geographies. As you can see, the other entities are not under the umbrella of the GDPR. Therefore, any transfer of personal data between the affiliate 2 and 3 with the rest of the company must be done in accordance with the Chapter 5 of the GDPR. The Chapter 5 describes the mechanism that a company can use to transfer personal data outside the European Union. and in absence on adequacy decision of the European Commission, a company relies to the safeguard of the Article 46. And the most common use that you may be aware are the binding corporate rules, often used by large organizations, or the standard contractual clauses. You may now ask why I'm also including the privacy shield. In effect, the privacy shield, pardon me, the privacy shield has been declared invalid by the Court of Justice of the European Union. But we know that the Department of Commerce, the US Department of Commerce, is administering the Privacy Shield program. And each US company may decide to recertify or certify in compliance with the Privacy Shield. It's not obviously compulsory, but if a company decides to be part of this framework, it's subject to the investigatory and enforcement power of the Federal Trade Commission and the Department of Transportation, which also ensure compliance with the Privacy Shield principles. Also, the Privacy Shield makes allow individuals to use independent recourse mechanism, which is have no cost for individuals that want to use this mechanism to lodge a complaint against a company that is breaking the Privacy Shield principles. In addition, in certain cases, there is also an arbitration mechanism that is available to individuals. And to conclude, a company shall put in place the compliance model that best fits with the organizational structure, but at the same time that best protects the personal data that the organization is processing. Thank you very much for listening.
Thank you. Thank you, Fabio. And well, thank you everyone for your presentation. So now let's open the floor for a Q&A. We have some questions already, but well, I believe that after all the attendees have processed all the information gathered during the 3 presentations, we'll be able to get a bunch of more other questions. So let's remember that if you want to send a question, you just need to send us through the questions tab that it's on the right side of your screen in the on your screen in the control panel of GoToWebinar. You might see a tab that says questions. So click there and send the questions to our speakers, and we will be more than happy to address all of them. So we have some questions already. Let's start with those first, and let's go from there. Let me check here the first ones that we got. First one, our company has an online store where we offer products that we ship worldwide. Do we have to appoint a European Union representative?
Well, I will answer the question. And if the services offered in the website are specifically addressed to European citizens, yes, the answer is yes. You have to appoint a representative in the European Union. The question is, in which country will we appoint this representative? No, we'll have to have information about the concrete website, the concrete services offering, and take a decision about that. No, because there is not a clear criteria on where do I have to appoint this representative? But the general answer is yes, yes. You have to appoint a representative here in the European Union.
Thank you, Felix. And one additional question that came to my mind is related with this one. And what happened about services? Services provided in the United States, a company that provide consultancy services in the United States, but some companies from Europe might be interested in those services. In that case, do they need also to have a EU representative?
Yes, no doubt. No doubt, because they will treat with they will process data of European citizens. Although being a service provider for European companies, so my answer is yes. I'm sure they have to appoint a representative, and not only to appoint a representative, but also comply with the complete GDPR, because the American company will be considered a processor in the GDPR, and then they will have to comply with a lot of obligations if the attendees want to check, go to Article 28 of GDPR, and they will read a lot of obligations on that. But if you are an American company and you have contracts with European companies that use your services, the answer is again yes, not only representative, but also to comply with the complete GDPR. I always say that GDPR is like a big octopus that tries to catch all the world with their tentacles. That is a good image for me, that we Europeans try to think that we are the center of the world, and we obligate the rest of the world to comply with privacy legislation.
Thank you so much, Felix. And in fact, we have a question that is related to that, continuing that conversation, which is, do you think that the European Union is going or is taking the path of enforcing the GDPR outside their borders?
Yes, of course. You have a lot of examples. For example, the best examples are from the big sanctions, the big fines that, for example, Google, Meta, now Facebook, and they have received a lot of fines, millions of euros. Amazon too. Just to give you 4 names, but our attendees can check, and European Union is enforcing the obligation of complying with GDPR, no doubt about it.
But the debate here, and I've heard that a lot, is that yes, of course, the European Union it's addressing some of those companies you mentioned, big tech companies that everybody knows about them, and I'm sure that also it's like an exemplary measure, no, so that everyone knows what's going on. But the real question is, how far is the European Union want to go that path? Because many people think that if they go that path right away or until the end, the United States is going to put a stop on that, and probably is going to say, be careful what you're doing, because you are messing with US companies, and you don't have a proper influence and regulations here. No? And they could, bring some other measures, and that's the debate in the street.
Yeah, no. In my opinion, I will pose you another question: is do European companies, do North American US companies, will they take the risk of losing the European market just for not complying with GDPR?
Depending on the border.
Depending on the border, yeah. Depending on that it's not difficult to comply with GDPR. For example, I had a conversation with a customer in which it was a North American US customer, and they told me, do you really think that we are not compliant? No, yes, of course. You can comply with a lot of obligations like security measures and so on. But I insist on the thing I have told you I have told you all about what is GDPR. GDPR is like a highway code of how to drive with European data. And it's not so complex. of course, the company has to make an effort in understanding that, in just adjusting some processing businesses and business processes and so on. But it's not so difficult. So the question would be, would you risk to lose European market or to lose European customers just for not doing that?
We'll see. Many people are sending their questions related with this. I believe that this question was already answered, but since there are a few of them, Nuria is asking, you mean that all US companies with European customers might have this representation in Europe?
We can analyze every company, but at the beginning, I can say yes, because if you are obligated by GDPR.
Wonderful, thank you. Another question Paul sent us in is asking, does the GDPR apply to European citizens residing abroad? Example, a Spanish citizen living in the United States. Is it nationality or residency?
Residency.
Okay, good. Thank you. Thank you so much. Let's see, more questions. We are not aligned with the European standard. What should we do in case of data claims by European citizens? Fabio?
Shall I go?
Yeah.
Will I go? Well, generally, if each company should have a privacy policy. The privacy policy is the best place where a company explains to data subjects what they're going to do with the data of their customers, subscribers. And at that point, a company should have a point of contact to make sure that any request coming from a data subject will be expedited within the terms of the GDPR, and shall put all the internal process to make sure that if it's a data subject is want to exercise one of the rights of the GDPR, that the GDPR granted, they can do it. Privacy policy is probably one of the most important things that a company has to have their website. Sometimes my colleagues, my procurement colleagues ask me, what is the first thing that I need to check to see if I can approach a new vendor? And I say always, check their privacy policy. If they don't have a privacy policy, probably don't even start having a discussion with them. So privacy policy is the first point to start.
Wonderful. Thank you so much, Fabio. I think it's a nice advice. So I suggest everyone here to check their own websites and check if we have a privacy policy in place there. So that's a good thing, first step to do. Thank you so much. Next question that we have. Now, we are developing a project to offer our customers IoT solutions for their business, but we are not quite sure if the information we process is affected by GDPR rules. What should we do?
Okay, so I answer that. Well, first, I would like to say that in the same way that GDPR, the territorial scope of the GDPR, the future AI regulation stays the same, that will be of application independent to companies independently where they are based. Okay, so for the question, in an IoT solution, first it has to be analyzed all the data life cycle, because it could be, we can have personal data in one phase and not in other, no? But apart from that, it's very difficult to say we have no personal data, because at the end, it's very probable that we could link an information to a device so that we have personal data. So if that data subject is European, will be of application for sure.
Thank you. Thank you so much. Next question. We are a B2B American company that we process data of individuals on behalf of our clients who offer their services to Europe. Does GDPR apply to us?
However, yes. Yes, again, because if they process data, if they process personal data of your residents, and you are providing services to this B2B, to this business, they will exigate, they will obligate you to comply again, because there is a general obligation of compliance. When you choose one service provider, you have to check whether it is compliant or not with GDPR, wherever they are, even in the Antarctica.
Okay. Thank you so much. So yeah, we are learning that almost everyone that it's connected to the internet is going to be subject of being under the GDPR regulations. So there are a lot of things that we must do. Okay, next questions that we have here. We heard in the news lately that the European Union is banning the TikTok app in the cell phones of their employees. How does the European Union guarantee that GDPR its compliance with companies like this one that have servers worldwide?
Maria, Fabio.
No, I don't understand very good the question. O sea, from one side, from European Union has banned the use of TikTok, so for civil servants, but the other, how?
I believe that the question it's focusing on one side they are banning the use of the app on specific cell phones, but for the general public, it's not banned, it's open. And we believe that they should comply with GDPR, of course, in that term. But so it's kind of counterintuitive. If you're not banning everything, you're not believing that they are complying with GDPR, no? At some point.
But we cannot ignore that one thing is the laboral context, and the other thing is what a person can do freely in his life. No one can ban the use of an application, no? There has to be freedom to choose.
Yeah. But imagine, Maria, that, for example, the United States, I think it was yesterday or a couple of days ago, they have delivered an order to the federal agencies they have to delete this application from all the government devices, no? And it is a matter of national security. And I think that European Union decision is the same one. You have to delete all TikTok apps in your phone. But there is something I say about that, because it's all about security, national security matters. But imagine if I am a civil servant of the European Union, I am at home, and I am at home with my wife. You can ban me, you can prohibit me to install TikTok, but if my wife has TikTok and they have information about who I am and who is she, what is the sense of this measure? It's very complicated to to ban information. It's very complicated to control that things, because it is not a simple matter of don't install that. It's a matter of the complete environment of the person, of the civil servant, or the public servant. It's very difficult to control that. It's very, very, very difficult. That is a first line security measure, but at the end, it's highly complicated to manage that.
Okay, thanks so much. Next questions. Are there plans of working on a common regulation about data privacy policies in the United States and Europe? Any news about that? Is there something that you heard that is on the process or working or not? Or we are doomed to comply with 2 different regulations for the next 20 years? What do you think?
They are working on this process. We can remember, we remember the executive order delivered by President Biden. But let's go to reality again. It's the same case that the banning of TikTok. We have suffered two scams now, and I bet we will have a third scams now. Once the negotiations between the European Commission and the US, once these negotiations are finished, I bet that they will fail again. Why? Because not only United States, but the European countries, they have all necessities of spying the rest of the world. It's hard to say that, but if you are the hegemonical power, you need that. So let's see how the negotiations are continuing. But my bet is that it is completely impossible to stop doing that kind of things, like spying the rest of the world. It's completely impossible. So it's impossible to give guarantees to people. For me, it's my opinion. I don't know if Maria and Fabio agree, but it will be very difficult to find a point in which United States and Europe reach an agreement. Maybe they will sign in a couple of months, 3, 4, 6 months, 1 year, but the final result will be a Schrems 3.
Yeah, but I think the most desirable solution would be to reach an agreement, because we live in a global situation. So for global problems, we have to have global solutions. So we need to have an agreement and to be able to live together, no?
Yeah, no doubt about that. I think it will help things in the business community, at least, to have a common regulation that everyone knows how to implement it, and that works both ways, not only in the European Union, but also in the United States. And well, I bet that doing that globally might be very difficult, but just with an agreement between the European Union and the United States, that will be huge. And probably some other countries would join. So I know that's difficult, but I'm with Maria there, and that's the desirable future. No? But I understand Felix, and I know that geopolitics are difficult, and that's a complex issue, no, for that. But we'll see. We'll see how everything evolves.
But you know, if you think that many US states now have their own privacy law, and there is the risk that US will have 50 different privacy laws if they don't put in place a federal privacy law. And probably at that point, once you have a federal privacy law, which is similar to GDPR, the communication between the European administration, the US administration will be a lot easier, and perhaps the risk of another Schrems 3 will be reduced, let's say that way.
No worries. Let's see, but let's hope for that. Let's hope for that. Another question that we have, in case we are a US company and would like to comply with GDPR, can we contact your company in Spain or your company in the US for that? Maria or Felix?
Wherever they want, they have the email in the screen, and they can write. At the end, the process will be the same.
Okay, so disregarding where they are located, you will navigate and ask them where they need to. Okay, yeah. Perfect. Let's see. We have 4 or 5 more minutes, so if anyone would like to send some additional questions, we will be more than happy to address them. I'll remind everyone that this webinar is being recorded, so you will be able to share all the information with your colleagues and friends interested in these matters, in these issues, and we will also share the presentation so that you can also have that in case that you need it. And for questions, just click the questions tab that it's included in your control panel, and you can send us those questions. We have a few minutes left so that we can address those questions at first. Meanwhile, we get more questions here from the audience. Let me check. Maria, one question for you. Does the Latin American countries have or are working on regulations similar to GDPR, or those countries are trying to bring their companies to comply with GDPR from Europe, or more with the data regulation that it's in place in the United States? I'm asking this because many countries in Latin America, they look to the United States and try to apply some regulations that they have already in place for some different issues, for example, for trade. And in some other cases, they look up to the European Union and try to some way imitate regulations that might be interesting for their countries. What do you think is the case for GDPR? Are more open the Latin American countries to mimic the GDPR from the European Union, or to mimic the regulation in the United States?
Which country, sorry, LATAM?
Yes, in LATAM in general.
Okay, so in LATAM, yeah, it's a strong influence of European laws. So before, with the directive from 95, and now with the GDPR, so there is a strong influence on their own national law. So I think they already are complying with GDPR, more or less. So they are used to this. It's nothing new for them, for these countries.
Okay. And that is also a strong incentive for US companies to apply GDPR, because I mean, there are a lot of companies in the US that are doing business in Latin America. And so if those countries already are working with that, it will be easier for the US companies to enter those markets. So that's a nice incentive as well. Okay, very good. I don't see more questions coming right now, so let's wrap it if you like. It's almost 12 o'clock, so 1 hour. Well, I would like to thank Maria, Felix, and Fabio so much for spending this time with us. We learned a lot about GDPR and IoT. And thank you to Telefónica for helping us to navigate these complex situations, but not as complex as it seems. So if anyone needs help to comply with this, you can call our panelists today, and they will be more than happy to help you and to solve any other questions that you might have. I understand it's a complex process and they would need to study your specific case, but I'm sure they have many different solutions that will be very efficient for your businesses. Thank you all the audience for participating as well in this webinar. I hope that you enjoyed it and you learned something today, and we hope to see you in the next one. Please don't forget to check our website, which is SpainUSChamber.com, and there you will be able to find all the events that we are hosting in the Spain-US Chamber of Commerce. Nothing left. Thank you so much, everyone. Maria, Felix, Fabio, and thank you all the attendees. Have a great day.
Bye.
Bye.